Today we are talking about something a lot of you have been waiting to hear. A federal court has just handed down a ruling that directly affects thousands of pending USCIS applications. And for once, this is actually good news. If you have been stuck in limbo, wondering why your green card case has not moved in months, this video is for you. We are going to break down exactly what this ruling says, who it affects, and what it does and does not mean for your case. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's take a closer look at what actually happened. On June 5, 2026, a federal judge in Rhode Island named John McConnell issued a major ruling in a case called Dorcas International Institute of Rhode Island versus United States Citizenship and Immigration Services, or USCIS for short. The judge found that USCIS had been placing certain immigration benefit applications into indefinite holds, meaning the agency was neither approving nor denying them. Instead, cases were simply sitting there, sometimes for a very long time, with no decision at all. The judge ruled that this practice went beyond what the agency is legally allowed to do, and that it violated a law called the Administrative Procedure Act, which requires federal agencies to act within their authority when making rules and decisions. As a result, the court struck down 3 specific USCIS policies. These are known in immigration circles by their policy numbers PM 602-0192, PM 602-0194, and PA 2025-26. In simple terms, these were the internal rules USCIS had been using to justify freezing applications from people connected to certain countries. The final judgment in the case was entered on June 11, 2026, and USCIS was ordered to start adjudicating these cases again. Now here's what you need to know about who this affects. The policies in question were part of a broader adjudication pause that applied to applicants connected to 39 designated countries. This pause covered a wide range of case types, including green card applications, naturalization cases, employment authorization documents, and asylum-related applications. So if you or a family member filed one of these applications and your case seemed to just disappear into silence with no request for evidence, no interview notice, and no decision, there is a real chance your case was one of the ones affected by these holds. According to court filings, the plaintiffs in this case were non-governmental organizations and labor unions representing millions of people who had filed immigration applications and were left waiting without answers. That gives you a sense of just how broad this issue was. To be clear, this was not a small technical dispute. It touched an enormous number of pending cases across the country. But what does this mean for your case specifically? Here's the most important part, and we want to be very honest with you about it. This ruling does not force USCIS to approve anyone's application. What it does is remove the legal basis USCIS was using to avoid making a decision at all. In other words, the agency can still deny a case if it does not qualify. What it can no longer do, at least for now, is leave your case sitting untouched indefinitely just because of where you or your family are from. Reports suggest that USCIS quietly began lifting some of these processing holds even before the final judgment, including for physicians and their family members who had pending petitions filed by employers. Following the court order, the agency issued a public alert confirming it would follow the ruling while it considers further legal options. USCIS said in its own statement that it strongly disagreed with the court's decision but would comply with its terms while the case continues through the legal process. While there have been some modifications and pushback from the administration, the story does not end there. The government asked the same court to pause its own ruling while it appeals to a higher court, called the First Circuit Court of Appeals. On July 15, 2026, the judge said no. The court denied that request, finding that the government was not likely to win the appeal and that allowing the freeze to come back would not serve the public interest. What this means in practical terms is that, as of right now, USCIS is required to keep processing these applications normally. However, before jumping to conclusions, it is important to understand that the appeal itself is still active. The case number at the First Circuit is 26-1703, and legal analysts note that the pause could theoretically be reinstated down the road if the government eventually wins on appeal. So this is genuinely good news today, but it is not necessarily the final word. So what should you actually do with this information if you have a pending case? First, if your application was one that had been frozen without explanation, especially if you are connected to one of the 39 countries covered by the original pause, you should expect USCIS to resume working on it. That does not guarantee approval, but it does mean the silence should be ending. Second, if your case is still not moving and you are not sure why, do not automatically assume this ruling is the reason. In practical terms, delays can come from many other sources, including background checks, staffing at your local field office, or missing documentation, so it is worth checking your case status directly and considering whether a status inquiry is appropriate. Third, keep an eye on the appeal. Immigration experts note that court fights like this one can take months, and while the current outlook favors applicants, policy in this area has shifted quickly before, so staying informed really matters right now. Let's also talk about the bigger picture, because this case did not happen in isolation. Beyond this ruling, the administration has pursued a number of other immigration policy changes this year, and several of them have also ended up in front of federal judges. In a separate but related case, 20 state attorneys general successfully challenged a different policy that had imposed a very large supplemental fee on certain employer-sponsored applications, and a court found that fee to be unauthorized. Around the same time, USCIS also issued updated guidance affecting how long certain employment authorization documents, known as EADs, and filed on Form E-766, remain valid. Taken together, these developments show a pattern. Courts have been stepping in repeatedly this year to review whether USCIS and the broader administration have stayed within the legal authority Congress actually gave them. Legal analysts suggest that this pattern is likely to continue, since several of these cases are still working their way through the appeals process, and each new ruling can shift the landscape again, sometimes within just a matter of weeks. For applicants and their families, this back and forth can be exhausting to follow, and we understand that. As a green card applicant or a petitioner waiting on a family member, this situation might feel like the rules keep changing under your feet, and in some ways, they genuinely have. That is exactly why we recommend not making major life decisions, like booking travel, giving notice at a job, or making housing plans, based solely on a single court ruling until you see it reflected in your own case status or an official USCIS communication. Case processing systems can take time to catch up with legal decisions, so patience, while frustrating, is still the safest approach right now. This situation might feel overwhelming if you have already been waiting a long time, and honestly, that frustration is completely understandable. Waiting without any explanation is one of the hardest parts of the immigration process. But this ruling represents a real shift. Advocacy groups that brought this case argued that leaving people in permanent limbo was never something the law allowed USCIS to do, and for now, the court has agreed with them twice, first by striking down the policies and again by refusing to pause that decision while the appeal plays out. The real question going forward is how quickly the backlog of frozen cases gets worked through and whether the appeals court ultimately agrees with the lower court's reasoning. We will be watching this case closely and will bring you updates as soon as anything changes. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.